Okay, this is our jury charge reading for Performance Challenge week number 6. Paragraph. Members of the jury, comma, that is the evidence you will hear in this case, comma, so you should have your seats, comma, copies of the final jury instructions, period. I am going to read those as I did with the preliminary instructions, comma, and you may read along with me or not, comma, as you choose to do then, period, paragraph. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them, period. You must follow these jury instructions, period. They are rules you should use to decide this case, period, paragraph. It is your duty to determine what the facts are in the case by determining what actually happened, period. Determine the facts only from the evidence produced in court, period. When I say evidence, comma, I mean the testimony of witnesses and the exhibits introduced into court, period. You should not guess about any fact, period. You must not be influenced by sympathy or prejudice, period. You must not be concerned with any opinion you feel I have about the facts, period. You, as jurors, comma, are the sole judges of what happened, period, paragraph. You must consider all these instructions, period. Do not pick out one instruction or part of one and ignore the others, period. As you determine the facts, comma, however, comma, you may find that some instructions no longer apply, period. You must then consider the instructions that do apply, together with the facts as you have determined them, period, paragraph. In their opening statements and closing arguments, the lawyers talk to you about the law and the evidence, period. What the lawyers say is not evidence, comma, but it may help you to understand the law and the evidence, period, paragraph. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, comma, you must disregard it and any answer given, period. Any testimony stricken from the court record must not be considered, period, paragraph. The law does not require a defendant to prove innocence, period. Every defendant is presumed by law to be innocent, period. You must start with the presumption that the defendant is innocent, period, paragraph. The state has the burden of proving the defendant guilty beyond a reasonable doubt, period. This means the state must prove each element of each charge beyond a reasonable doubt, period. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable, period. In criminal cases such as this, comma, the state's proof must be more powerful than that. It must be beyond a reasonable doubt, period, paragraph. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt, period. There are very few things in this world that we know with absolute certainty, comma, and in criminal cases, the law does not require proof that overcomes every doubt, period. If, comma, based on your consideration of the evidence, comma, you are firmly convinced that the defendant is guilty of the crime charged, comma, you must find him guilty, period. If, comma, on the other hand, comma, you think there is a real possibility that he is not guilty, comma, you must give him the benefit of the doubt and find him not guilty, period, paragraph. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily, period, paragraph. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats by any direct or implied promise, comma, however slight, period. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances, period, paragraph. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and by applying these jury instructions, period. You must not consider the possible punishment when deciding on guilt, period. Punishment is left to the judge, period, paragraph. The state must prove beyond a reasonable doubt with its own evidence, period. You must not conclude that the defendant is likely to be guilty because the defendant did not testify, period. The defendant is not required to testify, period. The decision on whether or not to testify is left to the defendant acting with the advice of an attorney, period. You must not let this choice affect your deliberations in any way, period, paragraph. The defendant is not required to produce evidence of any kind, period. The decision on whether to produce any evidence is left to the defendant acting with the advice of an attorney, period. The defendant's failure to produce any evidence is not evidence of guilt, period, paragraph. Before you may convict the defendant of the charged crimes, comma, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act, period. A voluntary act means a bodily movement performed consciously and as a result of effort and determination, period. You must consider all the evidence in deciding whether the defendant committed the act voluntarily, period, paragraph. In determining the evidence, comma, you must decide whether to believe the witnesses and their testimony, period. As you do this, comma, you should consider the testimony in light of all the other evidence in the case, period. This means you may consider such things as the witness's ability and the opportunity to observe, comma, their manner and memory while testifying, comma, any motive or prejudice they might have, comma, and any inconsistent statements they may have made, period, paragraph. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer, period. You are to consider the testimony of a police officer just as you would the testimony of any other witnesses, period, paragraph. The state has charged the defendant with certain crimes, period. A charge is not evidence against the defendant, period. You must not think that the defendant is guilty just because of a charge, period. The defendant has pled not guilty, period. This plea of not guilty means that the state must prove each element of the charges beyond a reasonable doubt, period, paragraph. Evidence may be direct or circumstantial, period. Direct evidence is the testimony of a witness who saw, comma, heard, comma, or otherwise observed an event, period. Circumstantial evidence is the proof of a fact or facts from which you may find another fact, period. The law makes no distinction between direct and circumstantial evidence, period. It is for you to determine the importance to be given to the evidence, comma, regardless of whether it is direct or circumstantial, period, paragraph. A witness may give an opinion of a subject upon which the witness has become an expert because of education, comma, study, comma, or experience, period. You should consider the opinion of an expert and the reasons, comma, if any, comma, given for it, period. However, you are not bound by any expert opinion, period. Give the expert opinion the importance that you believe it deserves, period, paragraph. Each count charges a separate and distinct offense, period. You must decide each count separately on the evidence with the law applicable to it, comma, uninfluenced by your decision on any other count, period. You may find that the state has proved beyond a reasonable doubt, comma, all, comma, some, comma, or none of the charged offenses, period. Your finding for each count must be stated in a separate verdict, period, paragraph. Intentionally or with intent to means that the defendant's objective is to cause that result or to engage in that conduct, period, paragraph.